Just to note that the recording is not going to be all the participants, it's just going to be the speakers.
Welcome, everyone. My name is David Grosky, and I will this evening be moderating our second session for the 2024 legal panel. We're very pleased and very proud to have Mark Weinberg for a second consecutive year as our guest speaker. Before we begin with my introduction of Mark, I'd like to, as I typically do, begin with our Devar Torah. And my Devar Torah tonight is going to build upon what I read this morning on LinkedIn from Rabbi Shimon, speaking about the importance of living an authentic life. I want to speak about that because I think it's a very important topic for all of us to keep in mind as we work through the challenges of life. Certainly for myself, having been a long-time incarcerated individual and coming out with the challenges that are involved with post-incarceration, I do everything I can in my life at this stage to live authentically. We often hear the term being authentic bandied about, especially in terms of social media, where it's easy to quite literally filter out the parts of ourselves and lives that we're not so keen on. Others may try to people please and inadvertently end up changing elements of themselves in an attempt to make others happy. But not living authentically can impact your mental and physical well-being in the long term. So what does authenticity involve and how can we achieve it? What does it mean to be authentic? Living authentically suggests you're being true to yourself in your relationships. Authenticity involves being in tune with your values and passions, being fulfilled, navigating life with purpose, prioritizing what brings you peace, and having tenacity and flexibility. It's a delicate balance between being open to constructive feedback to help achieve growth, but not allowing it to dictate one's perception of self, their abilities, or the possibilities that may exist beyond what others can see. How do we live an authentic life? We embrace silence, number one. There's so much going on in our lives and different perspectives come at us from different angles. So it can be easy to lose track of what makes you, you, and get swept up along with the crowd. If we need to, we seek therapy. Being authentic is a complicated process. And if you've been changing your behaviors or feelings to try to align with others, it can be hard to pick out what makes the real you. So in that respect, and if you need to, seek therapy. Learn to be vulnerable. Sometimes we don't show our authentic selves because we're afraid to be vulnerable. For some people, it can be hard or scary to open yourself up. Vulnerability can be rewarding, however, and it's a risk worth taking. And finally, be intentional. Consider what end and who you are investing your time in, particularly with individuals or activities that align with your core values, and making a commitment to them based on external expectations. 5 quotes I'll end with about authenticity. No legacy is so rich as honesty. It takes courage to grow up and become who we really are. Be yourself, not the idea of what you think somebody else's idea of you should be. And finally, the easiest thing to be in the world is you. The most difficult thing to be is what other people want you to be. Don't let them put you in that position. And with that, I would be very happy and proud to introduce again our guest speaker, Mark Weinberg. Mark Weinberg is a graduate of Highland Park High School and is a 1984 graduate of Yale College and a 1988 graduate of the Law School of the University of Chicago. Since 2001, Mark's been a solo practitioner with a focus on civil rights law. Since 2014, his main professional focus has been litigating the constitutionality of laws and policies directed at people convicted of sex offenses. Mr. Weinberg is widely regarded as an expert in the area of sex offense law and policy and regularly consults with criminal defense and civil rights attorneys throughout the country regarding such issues. We're once again very thrilled to have Mark back, and Mark, welcome.
David, thank you very much. And that was a beautiful Devar Torah, very thought-provoking. Thank you. There are actually 2 guest speakers, though, tonight. My co-counsel, Adele Nicholas, is also joining us and will share with the presentation. Adele, can you wave so everybody sees who you are? Okay, great. Adele has several claims to fame, but one is, well, my claim to fame is that I get to work as co-counsel with her because I'm very fortunate to do that. But two, she's also the executive director of Illinois Voices for Reform, which is the largest advocacy group in Illinois for reform of the sex offender laws. And she will talk about some of those laws. In general, we are thrilled to be here tonight. We are thrilled to be part of, in a little way, the Hinda Institute. They do amazing work, and we are, grateful to be connected to them in this way. Tonight, the presentation will proceed in this way, which is we have a series of slides that we want to show you guys that have different topics. The first topic is new laws in 2024 that affect people that have been convicted of sex offenses. Adele's going to talk about those. Two, we're going to talk about legislation that's currently pending in the Illinois legislature. Adele's going to talk about that. Three, I'm going to talk about successes we've had last year in our litigation efforts. Four, we're going to talk about ongoing litigation that we have right now. And five, and most importantly, we want to take your guys' questions. We always learn so much from this group through their questions. And I suppose we don't have to wait till the end to get questions, but if you have a question and can put it in the chat feed, it might be easier for us to address them in that way through the course of our presentation. So to begin with, Adele's going to put up some slides about the new laws that have been passed that are relevant to 2024.
Okay. Well, I'm not sure what I shared. Did I share my PowerPoint? Can everybody see that?
No.
Yes.
Or are you looking at my desktop or at my PowerPoint presentation?
Desktop.
Let me stop that and try to share the right thing here. Give me 1 second. Okay, do you see that now?
Yes.
Great. Okay, I'll just echo what Mark said. Thanks so much for having us here. Pleased to be able to share some info with you. I'll start with, as Mark said, just a couple of updates on new laws that went into effect that apply to people who've been convicted of sexual offenses. Several of them are good, positive changes that we hope will make people's lives a little bit more manageable. One new restriction, but I think it's a minor one that is manageable. And then I'll talk about some new legislation that we are working hard to support and try to pass this year. Okay. So a new law was passed to amend the Code of Corrections that went into effect January 1st, 2024. Although the law went into effect last month, I think we're not going to really see a lot of it carried out until June of this year for reasons that I will explain. But this changes the Code of Corrections to bring some relief to people who are on mandatory supervised release from some of the restrictions that apply to them. The first one is that for anyone on mandatory supervised release for any offense, not just a sexual offense, drug testing is going to require reasonable suspicion on the part of the parole agent, meaning that you can't just be randomly drug tested for no reason. The officer will have to articulate some suspicion that you are using drugs or having access to drugs before imposing a drug test. Second, people who are on supervised release will receive an automatic award of 90 days off their MSR term for receiving any kind of educational degree, whether that's a high school diploma, an associate's degree, a bachelor's degree, a career certificate, or vocational certification. That unfortunately does not help people who have an indeterminate amount of supervised release time, 3 years to life. But for anyone who has some period of time less than that, you will be automatically awarded 90 days off that time if you get a degree. The law also imposes some new restrictions on the Prisoner Review Board in terms of the conditions of MSR that they are imposing and how they are supposed to go about imposing those conditions. So in the past, for people with sexual offense convictions, there was just a long list of mandatory conditions. The Prisoner Review Board had no choice but to impose them on anyone who has to register as a sex offender. Now, several of these restrictions are becoming discretionary, and they can only be imposed after an individualized assessment by the Prisoner Review Board. And these restrictions include restrictions on using the internet and having contact with a child. It's supposed to be based on the risk and needs assessment, which is an assessment that the department is supposed to do with anyone being released from custody prior to their release. So the Prisoner Review Board is supposed to obtain that report, read it, and get some knowledge about the individual, their offense history, their history while incarcerated, progress they've made, therapy, or other programs that they've engaged in while incarcerated. Illinois is now coming in line with federal law, and that parole conditions have to be narrowly tailored, meaning they have to be only such deprivations of liberty as are reasonably necessary to protect the public. So there's going to have to be some sense of need for a restriction before the PRB will impose one. And the PRB is also supposed to take into account the individual circumstances. So for example, if somebody is a parent or has a type of job that requires the use of a computer, the PRB should take that into account when deciding whether to impose certain conditions. We don't have any data yet about how the PRB is carrying out this new mandate, but we hope to monitor this closely as more of our clients are getting out of prison onto mandatory supervised release. And we think it's a good law and we really want to hold the PRB to it. So that's something we'll be looking at closely over the next year. There's also some new laws that are supposed to help people who have indeterminate amounts of MSR clarify the process for terminating their MSR. So a lot of individuals with sex offense convictions receive an indeterminate amount of supervised release ranging from 3 years to natural life. And it's always been quite random what somebody has to do to actually finish their supervised release successfully and be discharged from department custody after they're out on supervised release. So the law changed in 2 ways that I think will help people with this type of sentence. First, there's a new requirement imposed on the Prisoner Review Board. When the parole agent files a petition to terminate someone's supervised release, if the board is going to deny it, they have to say why, and they have to set forth in writing a list of steps or requirements the person must complete to be granted discharge at a subsequent review. So if you have been on the right track, doing everything you're supposed to do, your agent and your therapist agree that you are a candidate for termination of your MSR, the PRB sees it another way, they're at least supposed to tell you what they want you to do to be successful that next time you file the petition. Again, we don't have any data about how this is being carried out yet because it's a brand new law, but it's something that we want to follow closely because I think it's a good requirement, one that could potentially help a lot of people, but we obviously have to see what the Prisoner Review Board does with that. The second requirement is one that is being imposed on the parole agents. And this is also supposed to give clarity to folks who are on mandatory supervised release about what they're supposed to do to finish their supervised release successfully. So once every 6 months, the parole agent must assess the parolee's suitability for early discharge and provide the rationale for recommending or not recommending discharge in writing, both to the Prisoner Review Board and to the person who is on supervised release. So we think the department is going to start doing this June 1st, because that would be 6 months from when this law went into effect. But again, I am hopeful that this will give more clarity to people who are on supervised release about what they're supposed to be doing to successfully progress towards being discharged from department custody. And Mark and I are always happy to talk to folks who are going through this process and experiencing MSR. If they want to talk to us about how this is being carried out and applied to them, we're happy to talk it through with you. There was one new restriction passed by the legislature last term, and I think it is hopefully a minor one. That is really just an extension of existing law, maybe even just a clarification of existing law. But there are already restrictions on individuals who are classified as child sex offenders working at certain child-centric locations. There is a small new restriction added, which is that it is unlawful for someone classified as a child sex offender to knowingly operate, manage, be employed by, or be associated with any carnival, amusement enterprise, or county or state fair when persons under the age of 18 are present. And there's a definition in the law of what constitutes a carnival or amusement enterprise. So it's not going to be interpreted too broadly, our hope is, but that's just something that everyone should be aware of, that this is the one new restriction that was passed last year. And again, hopefully it's not going to affect too many people. Okay, that's kind of the end of new laws that went into effect this year. Oh no, I'm sorry, there's one more positive one that I wanted to cover. Okay, this doesn't just apply to individuals with sex offense convictions. This applies to anybody convicted of any felony in Illinois. For a long time, our state made it illegal for anyone who had been convicted of a felony to serve as the executor of an estate. So even if the conviction was decades ago, the person has a positive life, a strong family, and someone's spouse or parent wants them to be the executor of their estate, that was
I
illegal.
suffer through this right now. I actually have some, I'm sorry to interrupt you, but I actually had to have somebody else be the executor of my estate, and it's a real pain in the butt, and it basically costs you money.
Well,
It's
the
a real
good news
a-
is that that law has finally changed. So now
too
it
late for me.
is, yeah.
But what about if the estate's still open? If the estate's still open, is there any way to undo that? To be
Uh,
fair, I kind of got a patsy to be my estate anyway.
I am not an estate planning lawyer, so I'm not in a good position to advise you about how this would apply to a complicated situation like that. But as a general matter going forward, when people are writing their wills, you can make a person with a felony conviction the executor of your estate under certain circumstances. Person can't serve as an executor while they're in prison or jail. The person who is writing the will has to acknowledge that they know the person has been convicted of a felony and they still want the person to be the executor of the estate. And there are certain felony convictions that are still disqualifying, which hopefully don't apply to anybody here, but they are financial exploitation of an elderly person or a person with a disability or identity theft. So those two types of convictions will still disqualify somebody from being an executor, but otherwise, it is permissible for a person writing their will to name somebody who has a felony conviction in their background as an executor of an estate. The next topic I want to turn to is something I'm very excited about. I don't want to overstate where we're at on this. This is just a bill that has been filed in the Illinois legislature. It is not a law, and it's going to take a lot of hard work to get it to be a law. But we are excited about working on it. It would be a tremendous change that would help a lot of people who I think are in this room and a lot of people throughout our state. So I'll tell you a little bit about what this is. Senate Bill 2158 is a very important bill that would reduce the residency restrictions and make other important amendments to our registry laws and our residency restrictions. So currently, Illinois law imposes 500-foot residential banishment zones around schools, playgrounds, daycares, and other locations that cater exclusively to minors. Under this bill, the residential exclusion zones would be reduced from 500 feet to 250 feet. Under current law, someone who has established a stable home can be kicked out of that home at any time if someone opens one of these locations within 500 feet of them. So for example, if someone obtains a license to operate a home daycare within 500 feet of you, the person who is subject to this law is going to have to move, even though they didn't do anything wrong. This bill would correct that. It would grandfather in an existing residence. So once somebody has established and registered a compliant home, they couldn't be kicked out because someone else has decided to move in a location near them. This would also eliminate the problem of some creative lawmakers in the suburbs that have decided they can exploit this law to get rid of people who are on the registry. And many of you probably followed the news that happened in Joliet, and it's a situation that's still ongoing, where there was an apartment building that had several registrants living in it, and the mayor of Joliet decided that in response to public outcry, trying to get rid of this population, he would have the city purchase a house, knock it down, and turn this vacant lot into a playground for the sole purpose of getting rid of people from their own homes. It hasn't happened yet, but this law would prohibit that from happening in the future. This bill would eliminate the restriction zones around home daycares. That's very important because home daycares are unpredictable. We don't know where they're going to be located. They don't appear on maps. They're very difficult to identify, and they can spring up at any time in any private residence. So getting that out of the law would, of course, give people a lot more certainty and stability in their houses, and greatly reduce the possibility or the likelihood of their being kicked out of their homes due to the location of a new home daycare near them. For people who can't afford the $100 registration fee, it would make it clear that the local police department or the local registration authority must give a fee waiver. For individuals who are registering as homeless because they do not have a fixed address, it would get rid of weekly re-registration for this population and allow those folks to register on the same basis as everyone else who has to register, which is either once every 90 days or once annually, which would be huge for this population, because right now there are people who are doing everything they can to get back on their feet and stabilize their lives, but they have to spend multiple hours, sometimes as long as half a day, every single week, waiting in line to re-register. It makes it impossible for people to have normal lives, hold down jobs, take care of their own family caretaking responsibilities. So that would be very important. And then it would lower penalties for some failure to register offenses from a felony, which it currently is, to a misdemeanor. So as I said, great bill. Very important changes that would bring some much needed sanity to the law in Illinois. And this is being pushed by our friends at the Chicago 400, which is a coalition of people who've been rendered homeless by these residency restrictions, along with housing advocates, victims' rights advocates, people who've worked with people who are affected by these laws and have seen how badly they affect our whole state by making so many people homeless, making it impossible for people to have stability in their homes even after they establish them. So we are working hard to support this bill, and I think that there will be a lot of opportunities over the coming year to help in those efforts. So there's a couple of things you can do. One is our organization is called Illinois Voices for Reform. You can go to ilvoices.org and sign up for our mailing list. And there you'll get some periodic updates about ways you can help support this effort. For example, you can sign up to talk to your lawmakers. You can get involved in a legislative training to learn how to talk effectively to your lawmakers. And we're going to be having a symposium related to this in May that you'll get some more information about. So if you want to sign up for our mailing list, I'd appreciate that. And then also there's a link in a form here, which I will paste into the chat, where you can quickly and easily send a letter to your lawmakers asking them to support this bill and explaining why it's so important. And I will pass it over to Mark to talk about some of the litigation that we have worked on and are continuing to work on.
Okay, great. Good job, Adele. Can you take this off for a second? Because there's a good question, I think, in chat that both of us should address about the new changes that the PRB is supposed to implement related to how to get off of MSR. And this is a big question. How is the PRB, how are the PRB and the parole officers actually going to implement their obligation to give people direction as to what they have to do to get off of MSR in Illinois? And this is a problem. Adele and I have for a couple of years now thought about bringing a lawsuit because there is no clarity in the law as to what exactly people have to do to get off of MSR. It's very discretionary. It's pretty much left up to the parole officers to submit people for a petition to get off of MSR. And without any guidance, it becomes totally arbitrary and discretionary. So we are going to monitor how this new law is going to be implemented. But the question in the chat is, well, what stops the DOC from implementing a blanket policy forbidding their agents from recommending early release? And I think the answer to that is, if they institute a blanket policy against early release, then they're not giving the proper guidance to people of how to get off of MSR, which we believe would be a violation of due process. We're not prepared to jump and do that lawsuit right now because we want to wait to see what, in fact, the parole officers and the PRB do in trying to give people guidance as to how to get off.
Yes,
Adele, do you have anything to add?
I do, which is, I think, as a practical matter, the department by and large does want people to have a path to successfully complete 3 to life. We have lots of clients who have successfully completed MSR, who had 3 to life. It's not minimizing how difficult it is. You have to take it extremely seriously, be really focused, stay in compliance with everything for a sustained period of time. But we do have clients who've gotten that recommendation and the PRB has signed off on it. So I don't ever want people to lose hope that this really is a life sentence. I'm not saying it's easy. I'm not saying that it's a good process. It's not. It is a confusing one and it's a frustrating one, but don't lose hope. It is possible to finish MSR.
And then I think maybe Adele and I should both apologize because we know that there's a lot of people on this Zoom that are not in Illinois, and we're using, we were focusing on Illinois law, and we were also using language like MSR, and 3 to life, assuming that you guys all know what that means. In Illinois, MSR stands for mandatory supervised release, which is just our version of parole and supervision in other jurisdictions. In any case, if you have questions about anything we've asked, you can ask them later, or you can ask them later. Let's move on to some of the litigation issues. The first one is lawsuits that we successfully completed in 2023 that we actually got decisions on and that were resolved. There were 3 in particular, and I'm gonna actually move through these quickly because I think it's more important to get to the cases that are pending rather than have been completed. The 3 cases here all were residency restriction challenges in Wisconsin. Wisconsin imposes very draconian residency restrictions there, including in the middle case, the town of Paris has restrictions that prohibited people from living within 6,500 feet of a prohibited location and prohibited people from living within 6,500 feet of another person on the person on the registry. And we challenged that law, and it was a split decision. We won. The appellate court ruled that it is a violation of the ex post facto clause to prohibit people from living within 6,500 feet of another registrant. But unfortunately, the bad news is that the court upheld Paris's restriction on prohibiting a person from living within 6,500 feet of a prohibited location. That's bad news, but it's not as bad as it appears, because the court's justification for upholding that 6,500 feet restriction is that only 30% of the entire town of Paris was off limits. And because of that, a very significant chunk was available for registrants to live in. And we now are going to, hopefully in the future, try to clarify, well, what percentage of a town has to be off limits for it to violate the ex post facto clause. There are several towns that we're familiar with in Wisconsin that 80 and 90% of a town is off limits due to these residency restrictions, and we want to bring lawsuits against those towns. The other case was a case, the top case, Schrader versus Muskego, in which we won, in which the courts declared that so-called original domicile provisions were unconstitutional. Original domicile provisions were provisions in these ordinances which said you can only move, if you're a person convicted of a sex offense, you can only move back to our town if you lived in the town at the time you committed your offense. Well, this basically banishes from the town anybody who didn't live there, and the courts declared that to be a violation of the ex post facto laws, because banishment constitutes punishment, and retroactive punishment is the definition of violating the ex post facto law. The third case, Koch v. Heartland, that was an important case because we couldn't have really done the other two cases without it. And that was when we got the Seventh Circuit, the appellate court in Illinois, to overrule its previous understanding of what constituted retroactive. In order, again, for a law to violate the ex post facto clause, it has to be retroactive and it has to be punishment. And the court had an understanding of what retroactive meant that was inconsistent with the Supreme Court precedent. So we got them to overrule that, and that opened up the door for us to sue these various municipalities for their very severe residency restrictions. As Adele mentioned, in Illinois, the residency restrictions are 500 feet from a prohibited location. So the one in the town of Paris was 13 times more restrictive than that. And it's unfortunate, but there's a lot of towns in Wisconsin that have very bad residency restrictions. And it's part of our agenda to slowly but surely attack them. Okay, moving on, let's talk about some of our current cases. We've broken down these into 3 different sections: probation conditions, registration conditions, and what's the third one, Adele?
Just Wisconsin.
GPS, a law on GPS, which imposes a scheme that requires monitoring of people that have been convicted of certain sex offenses, GPS monitoring for life of people who have been convicted of certain sex offenses, and that's for life, even after they're off of any supervision of any sort. Anyway, we're going to take these one at a time. Adele's going to do one just to summarize what these cases are about, and then I'm going to do the other. So take it away, Adele.
All right. So the case Frazier versus Jeffries is currently before the Seventh Circuit Court of Appeals. We've challenged the constitutionality of the Department of Corrections policy prohibiting anyone who has a sex offense conviction from having contact with their own minor child. We have a preliminary injunction in the case, which improved the policy somewhat. It at least provided a path for folks to get consideration for their request to see their own children, but we still think the policy is quite inadequate, and we are asking the Seventh Circuit to require the department to do more to protect the constitutional interest in the parent-child relationship. And I guess I just want to say, as a preface to talking about all of these are all cases that are ongoing. So if any of these situations affect you, please feel free to reach out to Mark or to me, and we're happy to talk to you about how any of these cases might affect your individual situation.
The second case that's ongoing is Tucker v. Jeffries. It's a case that we filed in 2018, and it challenges the internet restrictions that are imposed upon people on MSR who have been convicted of sex offenses. The IDOC, the Illinois Department of Correction, has changed its policies 5 times since we brought this lawsuit. But even the latest policy, we believe, is unconstitutional, as it presumptively prohibits people whose crimes were related to internet use from having access to the internet at any time prior to their sex offender treatment provider granting them and their parole officer granting them permission. And sometimes that denial can last, well, it does last years and years. One of our plaintiffs has been denied internet access for 4 years. And of course, we think that violates the First Amendment. Yeah, you know, just in general, we think the restrictions that are imposed upon this population of people on parole are extreme and absurd and do not promote rehabilitation or reintegration into the society in any way, shape, or form. And we'll see if the courts agree. Adele?
The third case is called Stone versus Jeffries. This is the third in a series of cases we've brought pertaining to the Illinois Department of Corrections policy of keeping people in prison during their MSR period, so beyond the time they were sentenced to serve in prison, if they can't afford housing that the department will approve that meets all of the restrictions imposed by Illinois law and departmental policy. So we saw a lot of our clients getting stuck in prison for long periods of time after they had already completed their sentences if they couldn't afford a place to go. The situation is slowly but steadily improving as we've gotten, this is now the third injunction we have in the Stone case, but we're still closely monitoring the department's policies about releasing people who can't afford their own housing. There is now a transitional housing program for individuals who have to register as a result of these injunctions. We still have some questions about its adequacy, particularly for people who have physical or mental disabilities, but there is an injunction in place, and we're asking the court to keep enforcing it until such time as the department can really demonstrate that people are being released on their release dates.
The fourth case that we have challenging parole MSR restrictions is called Narsal versus Hughes, and that is a challenge to a parole restriction that prohibits people who have been convicted of sex offenses from using or possessing erectile dysfunction medication. We believe this interferes with people's intimate privacy rights and relations, and is just another horrible restriction and should be declared unconstitutional. Narsal, by the way, is an organization which I sit on the board of directors of and have since April of this last year. And it stands for the National Association for Rational Sex Offender Laws. And my role in the organization is I promised that I would bring 4 lawsuits on their behalf, with their organization being a named plaintiff. And And that's what this is the first one that I filed on their behalf in last month. This particular lawsuit has significance beyond the substantive claim, that is, that people should be allowed to use erectile dysfunction medication. And that's because in the circuit that we operate in, the Seventh Circuit Court of Appeals, the law is such that you cannot bring a challenge to a statutory parole condition under the civil rights laws. You have to bring them under what's called a habeas corpus challenge. And I don't really want to get into the weeds because it gets kind of detailed, but because you can't bring an action challenging a statutory parole condition under the civil rights laws, it makes it very difficult to challenge these laws under habeas. You can't get attorney's fees under habeas, and you can't bring class actions under habeas, and you have to go through all levels of the state court before you can get to federal court. All of it, which makes it, basically impossible to pursue these claims. So our main point in bringing this lawsuit is to try to get the Seventh Circuit to overrule its existing precedent. Adele?
Okay, Pottage versus Watkins is the only one on this list that pertains to people who are on probation rather than parole. So in 2022, we brought a lawsuit that found unconstitutional a condition that applied to people who are on parole that prohibited anyone on parole who has a sexual offense conviction from living at the same address or in the same building as another person who has to register. That law really, when you layered it on top of the 500-foot restrictions, made it virtually impossible for folks to find a place to live because, of course, we already only have small pockets that are in allowable zones. And then there's all kinds of rental discrimination. So if you find a landlord who is willing to rent to people on the registry and in a permissible zone, only one registrant could live there, even if it was a large multi-unit apartment building. So we challenged the constitutionality of that restriction successfully in 2022 in a case called Barnes versus Jeffries. And the Pottage case challenges an analogous restriction that applies to folks who are on probation. So we're cautiously optimistic that case is going in the right direction. It's certified as a class action on behalf of all probationers in Illinois who have sexual offense convictions, and it's a defendant class for all the probation departments in the state. And we will be moving soon for a permanent injunction trying to get rid of that law.
Oh, okay. Just two more cases to go through. Adele, can you explain this one? I think you could do it better than I can.
Sure. I'm very excited about this case. It's a new case that we brought recently. The Department of Corrections has a administrative order that empowers its records offices, which are basically records keeping officials at each prison, to review people's sentencing orders and, we believe, change the amount of time they were sentenced to serve on mandatory supervised release if they think that the sentencing court got it wrong. So the client on whose behalf we brought this case was sentenced to serve 2 years on mandatory supervised release, but a records office official believed that was legally incorrect, and she changed it to 3 years to life. And this, of course, kept our client on supervised release beyond the time he was sentenced to serve, even though he had a sentencing order that was clear about how much time he was sentenced to serve on supervised release. And on top of it, in his situation, the records office official was wrong about how much time he should have been sentenced to serve. So we think whether she was right or wrong, the department simply does not possess the power to override a sentencing order. And we are seeking class action status for this case to try to get a permanent injunction telling the Department of Corrections that they have to respect court orders. And if they think there's something wrong with it, the remedy is to follow the proper procedure in state court, not to just substitute their own judgment for the judgment of a sentencing judge. So we have talked to lots and lots of people who've been in this situation where they get a unpleasant surprise at the end of their prison term about how much time they're going to be on supervised release because the department is just substituting its own judgment for that of the court. So we are hopeful that we're going to be able to get rid of that policy and bring the department back in line with what we think the Constitution requires.
Okay. These are two, I think we should speed it up because I really want to get to the questions.
These are the last two things to cover.
Yeah, then we have the GPS for life. But yeah, so this is a challenge. McFarland v. Kelly is a challenge to the ability of the Illinois State Police, the ISP, to extend a person's registration period whenever they believe a person has violated his registration requirement. Believe it or not, for years, the Illinois State Police has exercised its discretion to unilaterally extend people's registration times based solely on their discretion when they believe a person hasn't properly registered. And we believe that violates a person's due process rights to have a fair and impartial hearing. And that case appears to be on the verge of settling. And we are only settling because the Illinois State Police is recognizing that they are violating people's rights by exercising such unilateral discretion. Did I say everything relevant to that case, Adele?
Yeah, I think that the important point is two things are going to happen as a result of the settlement. One is they are going to have administrative hearings in compliance with the administrative code, so that if someone contests that they violated the registry, they will have an opportunity to bring forth evidence of that. The state police shouldn't just be blindly relying on whatever a local police department tells them and extending the registration without giving a chance to be heard. So, and they're going to be giving notice to everyone who was extended, that they have a right to avail themselves of a hearing if they want one. So I think those are two positive things. And the last Illinois case we'll cover is called Cross versus Kelly. This is just a straightforward challenge to a state law, a section of the Illinois Sex Offender Registration Act that classifies anyone who has to register in another state as a sexual predator if they register in Illinois. So even if the person was convicted of an offense that Illinois would require 10 years of registration and would not classify as a predatory offense, if that person moves to Illinois and registers there, they're going to be labeled as a sexual predator and required to register for life and prohibited from entering parks in Illinois. We think this is a violation of equal protection. And so we've brought this case on behalf of somebody who's in that situation. So we're happy to talk to anybody else whom this has affected.
And the last case that is ongoing is Antrim v. Carr. It's a case that, again, we've brought in 2018, and it's been actually up and down to the Seventh Circuit Court of Appeals, and we actually wrote a writ of cert to the United States Supreme Court, but it was denied, and now we're back in the district court, and we've completed discovery, and we are in the midst of expert discovery. And that case asks the question whether it violates the Fourth Amendment rights of people to require, as Wisconsin does, for certain people who've committed certain sex offenses to be on GPS monitoring for life, even after they've completed their supervision. It sounds like it should be an easy case to win, but alas, there's no such thing. Okay, now, oh my God, any questions? I hope so. Okay, I'm going to ask a question though, but because Laura, I was on the call last last week with Alan Mills, and I thought your question was, is there any reason for hope? And I haven't stopped thinking of your question to Alan Mills. And I guess I want to say, I believe strongly that there's lots of reasons for hope about, improving the situation for people who have been convicted of sex offenses, that there's a lot of worthwhile litigation going on. Adele and I are doing a lot, but there's some unbelievable work that's also going on in Michigan right now, challenging their registry. And I believe there's going to be some significant developments on the ability of states to put everybody and anybody on their registries, and that the time periods are going to be reduced. And as Adele said earlier today, the scholarly literature and the sociological data about how bad these laws are just becoming clearer and clearer. And it's only a matter of time before the courts are going to acknowledge that these laws are ineffective, and worse than ineffective, counterproductive. And so I want to say there's lots of hope for things getting better. There's reasons for hopelessness too, because things take time, and our societal attitude towards people that have been convicted is horrible and mean-spirited, but there's reason for hope. Sorry.
Yeah, I see a question in the chat about, can you speak about how ineffective these laws are? Residency restrictions have been studied over and over and over again, and they've been proven over and over and over again to do absolutely nothing to reduce or prevent reoffense. In fact, they've been found to just be drivers of homelessness and instability, joblessness, and reincarceration. And there's actually, the evidence has become so clear that the Department of Justice itself published guidance that says these laws, there is nothing to recommend that residency restrictions be implemented. So our task as lawyers and advocates is to keep bringing forth the evidence, educating our lawmakers, educating the courts about what the evidence is, and we're going to keep beating that drum. There's some hands up. Mark, do you want to call on people?
Oh, sure. Laura.
Any other questions for Adele or Mark? Adele and Mark, thank you so much for your tremendous and valuable time this evening and your presentation. Elizabeth, thank you too, and we'll be looking forward to your presentation next week.
Thank you.
We're so pleased that mostly everyone who attended this evening stayed with us, which is a testament to Adele and Mark, of course. And we look forward to seeing you all next week. Thank you all so much for being with us this evening.
Thank you,
Night.
David.
Thank you. Thank you, Adele, also. I'm sorry we have to introduce you honorifically.
No worries. It was lovely to be here. Thanks for having me.
Thank you so much.
Adele, just another thing. I'm going to send out an email about the 500 group. If you have something that you have pre-done, I'll blast it out to our HINDA people.
Great. I would love that. I will send you the email that we sent to our listserv, and you can feel free to adapt that as you see fit.
Yeah, we're social workers and we suffer a lot from these laws. So we really want to support change.
So do we, for sure.
Thank you.
Have a great
Thank
night.
you all. Thank you all. Everyone have a great evening. Thank you. Good evening.